I'm Las Vegas criminal defense attorney Michael Becker. Most people know what a trial is, but many are unfamiliar with preliminary hearings, which occur far more often than trials. Here are 5 things to know about preliminary hearings in Nevada. 1. A preliminary hearing, which is also called a probable cause hearing, is where the state tries to persuade the judge that they have enough evidence to continue prosecuting the defendant. 2. Defendants have a right to a preliminary hearing 2 weeks after their arraignment, which is when defendants are formally charged. 3. The only defendants entitled to a preliminary hearing are those charged with felonies or gross misdemeanors. And defendants who get indicted by a grand jury, which is a very small minority of cases, do not have the right to a preliminary hearing. 4. If the state wins a preliminary hearing, the case will be transferred from justice court up to the district court and set for trial. Meanwhile, both sides can continue trying to plea bargain the case. If the defendant wins the preliminary hearing, then the case should be dismissed. However, the defendant may later be arrested on the same charges if the state decides to pursue a grand jury indictment. And 5. It is more difficult for the defendants to win preliminary hearings than trials. This is because in preliminary hearings, there is a very low bar of evidence that the prosecution must meet. Still, preliminary hearings are useful tools for seeing how strong the state's case is, and this can help defendants decide whether it's in their best interest to ultimately take a plea or pursue a trial. If you or a loved one is facing criminal charges in Nevada, call my legal team at 702-DEFENSE for a free consultation. The attorneys at the Las Vegas Defense Group are here to fight for the best resolution possible in your case.